Hello, and welcome to this Australian-New Zealand Women's Declaration International webinar for August 2024. My name is Janet Fraser, coming to you from Gundungurra, west of Sydney. I'm the convener of the Feminist Legal Clinic in Exile. Tonight, I have Anna Kerr and Bronwyn Williams from the Feminist Legal Clinic doing tech with me. Wherever you're coming from this evening, we pay our respects to elders past, present, and emerging, but particularly the women of this continent. We have 3 speakers tonight whom I'll introduce in turn. A reminder that the presentation is recorded and question time is not. When we end for question time, I'd appreciate it if women used the Q&A for written questions so I don't lose them in the chat. If you wish to speak, please use the raise your hand icon and I'll keep a running list of the order in which I see you appear. And now to introduce our excellent panel. Jan Rivers is Genspect's New Zealand spokesperson, a former public servant whose roles were in information management, library services, and information policy. She is also a lesbian, an activist on public issues, and works part-time as a meditation teacher. In 2018, she recognised gender ideology as a threat to the public sector, to social cohesion, and to women, children, and same-sex attracted people. She helped found some of New Zealand's gender-critical organisations and is the author of articles on the impact of gender ideology on government and the dangers to children and young people of gender medicine. Jan will talk about the current review of the protections in the Human Rights Act 1993 for people who are transgender, people who are non-binary, and people with innate variations of sex characteristics. The review has not met the usual standards for creating an issues paper, including failing to determine any of the terms used in the review and adopting a gender ideology world context for the arguments. Welcome, Jan. Janet is the New Zealand country contact for the Women's Declaration International and a policy convener for the Women's Rights Party New Zealand. She has been active promoting women's sex-based rights in New Zealand for several years and helped to set up several groups who work to protect those rights. She is a mother and a grandmother. Janet has been concerned for some years about proposals to add gender to the Human Rights Act, which she has consistently opposed. Tonight, she will talk about proposals from the Law Commission to add gender identity and gender expression into the Human Rights Act and why this is a bad idea, focusing on how it breaches the Convention for the Elimination of All Forms of Discrimination Against Women, CEDAW. Anna Kerr is a founder and principal solicitor of Feminist Legal Clinic, Inc., with over 30 years of experience in legal practice. Her current practice is focused on advancing the human rights of women and girls. This includes supporting those harmed by extreme gender ideology who cannot secure assistance from other legal services. In 2023, Feminist Legal Clinic was granted special consultative status with the Economic and Social Council of the United Nations and is also the country contact for Women's Declaration International. Anna also has 4 children and is currently caring for her elderly mother. And tonight, I'd like to start by asking Jan to speak. Jan, please go ahead.
Kia ora koutou. Thank you very much for the invitation and the opportunity to talk about this very prescient topic. I've got some slides, so I'll move over to those shortly. But pretty much that's a good introduction of me. What I'm going to talk about really is not so much what my recommendations for the legal issues paper around including transgender, non-binary and people with innate conditions of sex development, but rather to talk about the nature of the issues paper and some of the reasons why its poor quality has made it very difficult for feminists and people who may not be entirely supportive of that proposal to respond to. So I'll just share the screen and then I'll get started in earnest. So I'll just give you some background first of all. The issues paper is open for 12 weeks. The consultation closes on the 5th of September. In theory, the nature of an issues paper is that it allows for competing rights and interests to be weighed. It says that in the document. So the Law Commission is a relatively recent creation of New Zealand's sort of public constitutional infrastructure, if you like. It's a part of government that the government itself can ask to do investigations of new novel law when law has become outdated, or when there are other problems or issues. It's sometimes used as a way of kicking a difficult issue into touch, and there's an element of that, I think, in the fact that the Law Commission has this paper. What else is there to say about the Law Commission? It's a small unit in government. It's probably underscoped for what it needs to be able to do. And this current work has taken, I think, about between 18 months and 2 years. And it started off as part of as I mentioned, a great way to kick a difficult issue down the road. There have been several attempts to include transgender people in the Human Rights Act over about 20 years. The first was initiated by the transgender MP Georgina Beyer, I think in about 2007, 2008. But the recent attempt has sort of had its origins in the aftermath of the Christchurch mosque attack. And what happened there was that the Royal Commission, which took place in the aftermath of that, didn't actually suggest anything really about other kinds of hate speech, but it did suggest that there needed to be legislation for hate speech. The government took that proposal and proposed that there would be legislation for hate speech about all of the protected characteristics in the Human Rights Act. In my view, the Minister for Justice, Kiri Allen, she was the Labour minister in the last government, she asked the wrong question, and the wrong question for a number of reasons. First of all, there's a great deal of difference between people with conditions of sexual development, physical, medical conditions, and transgender and non-binary people. And in a way, they've been put together in an artificial way to suggest that there's some kind of common ground. The Human Rights Act, the way that the piece of work was proposed was simply to check whether transgender and non-binary people and intersex people were covered adequately by the Act. So there was no attempt really, and that's one of the real problems with this piece of work. There was no attempt to determine whether women's rights would be undermined by action in order to cover the rights of these other groups. And so to a large extent, the paper really doesn't concern itself with that. And we're in a funny situation in New Zealand, which is that since 2006, when Georgina Beyer's private members bill was removed from Parliament, the situation has been covered by a Crown Law opinion. And that Crown Law opinion said that transgender and transgender people were covered by the sex-based provisions in the Human Rights Act. But that was a real piece of political brinksmanship, and it was a way of taking the private members bill off the agenda. And one of the things that the Crown Law people didn't do was to look at whether there are any reasons why transgender people should not be covered by the legislation. And there were such cases, but they didn't bother to look at them. And the one that I'm aware of is a case called Bellinger versus Bellinger. And it said that although self-perceived gender might be a relatively good idea to cover in one context, such as allowing marriage, it might not be appropriate in another, such as competitive sport. So all of those other pieces of case law which were looked for around the world, which might have argued for caution, none of them were taken account of. So that's sort of where we are. I've mentioned a little bit about what the Law Commission is, this idea of looking at novel legislation, reporting back to government on a proposal, doing some in-depth consultation, but it doesn't really gauge opinions across society. It only gauges the opinions from the from the submissions that are provided to it in the form of responses like the process that's open at the moment. And that's where one of the real problems occurs, which is that our gender identity community, if you like, is funded to the extent of probably tens, 20, $30 million a year through funding to NGOs, to government, from the private sector into genderist organisations. And that's not the case for the women who might want to respond and to ask some more nuanced questions about the wisdom of responding to the Act. And another thing that's an issue for New Zealand is that the Public Services Act, which I think came in about 2 or 3 years ago, has some provisions in it to say that all chief executives must take account of diversity, equity, and inclusion. And what that's meant is that they have really not done a huge amount around other issues like new migrants or people with disabilities, certainly nothing much to do for women, but it has meant that gender organisations have been invited into the heart of government. As far as I'm concerned, the way that the issues paper has been written is quite different from what we would expect an issues paper, a sort of serious, legally written issues paper to do. But it just follows on from what's been happening in New Zealand for the last maybe 7 or 8 years. And that is that when there's gender based and by gender identity based policy or legislation, what the government does is it appoints a group of self-interested people to work on the topic. So there's never any diversity across the issues. There's always one group of people from gender identity-based organisations and so-called rainbow organisations who get to really call the shots. And that's been the case in at least half a dozen consultations in the last 5 or 6 years. And there's also been the situation within New Zealand where sometimes government just makes policy without any consultation whatsoever. So, for example, the definition of women as self-identified took place within the Ministry for Women without any consultation, policy work, or anything else. And the same applied to our anti-conversion practices legislation. There was no kind of white paper process. There was just a petition that such a piece of legislation be enacted, and it was. So, what did the Law Commission do? It didn't really meet the usual standards for issues papers. I've looked at some of the historical ones, and they are all very carefully written. They all have definitions. They all have a glossary. They use very, very standardized, very accessible language so that people, whichever side of the debate they're on, can understand it readily. They don't have views that are prejudicial to one side or other. And because, of course, if you're thinking about new legislation, you're obviously very often talking about groups of people with different interests that need to be balanced. But that's not the case with the Law Commission issues paper. It uses views and ideas that are very prejudicial to women's interests. The questions that need to be answered are often very leading questions, kind of saying, well, what should be done that's good for transgender and non-binary people? And there are no questions which really lend themselves to kind of explaining why you might think that's a problem. There is some text in the depth of the document suggesting that they want alternative views, but it's fairly low on the priority list. And the process has addressed every section of the Act, including insurance and superannuation conditions, which were specifically put in place for men and women to be dealt with differently. For example, with insurance, because women tend to live longer than men, and because men tend to be not such careful drivers. And even those sections have been suggested that transgender and non-binary people might want to adapt those sections for themselves. So what all of this means is that women who are very poorly resourced have to do all of the heavy lifting to make the case that there be a different view than a gender ideology view. I'm repeating myself here slightly, the language is incredibly ideological. So women in this paper are regarded, are spoken about as cisgender women. It makes it very, very hard to understand actually what's being written about. And it makes it very difficult to believe that our concerns or the concerns of wider New Zealand are being taken seriously when the language is extremely off-putting to be able to respond to. There's no evidence, for example, in the text that I've read through pretty much the whole thing, that, for example, service providers who might be impacted by the need to provide services under this act have really been consulted. There is certainly no indication that any concerns they have been addressed. The paper makes a whole lot of claims that don't really stand up to inspection. There's no information at all about the demographics of the transgender and non-binary community as far as the paper's concerned. It's one sort of joined up community, it's not a community which is rapidly increasing amongst young women and young people generally. So, and the same applies to the innate conditions of sex development. There's no real explanation that such people are not, by and large, either on a male or a female development path. So it creates this kind of cloudy impression of two groups of people who kind of sit between the sexes. Doesn't do these definitions. There's no, that uses the terms like legal sex, but it doesn't define it, which might have been useful. It refuses to define gender identity. It doesn't describe gender as a synonym for sex. It describes it through the lens of gender ideology. And it also has a whole series of really quixotic decisions about what's in and what's out of scope, which I'll come to a bit later. Like it's excluded really gender medicine from being included in the scope, and yet it clearly is. And one of the biggest, real biggest concerns about if gender identity and gender expression or transgender and non-binary is included in the legislation, it has impacts on quite a number of areas of legislation. For example, film and video classification scheme would be affected, and it would mean that any film that addressed transgender and non-binary medicine, for example, from the perspective that maybe it's not a good idea, would be subject to complaints that might mean that they would have to be withdrawn, or that they would have some kind of, hazard assessment made against them, which is, that's this, the law has quite a lot of impact beyond the Human Rights Act. The issues paper describes core gender critical beliefs as if they were kind of strange and unusual. So, for example, a core gender critical belief is that sex is binary, innate, and immutable. Not that that's a belief that's held by probably the majority of the population. And it's a belief of gender critical women, according to the issues paper, that our rights are being diluted by a focus in public policy on gender identity. And it's a belief of only gender critical women that having a gender identity separate from one's biological sex is an expression of an ideology. So these are kind of quite, they're kind of wrong. They don't really capture gender critical beliefs. They express them in a way which is obviously intended to be pretty disparaging and also marginal. Yeah, the issues paper also goes well beyond the what it's intended to do. So, for example, it suggests that that even other gendered language, which doesn't impact on the provisions that would need to be put in place according to the paper in order to cover transgender and non-binary people, that even those gendered expressions be taken out of the human rights law. One of the other things that it does is the only reference to CEDAW is a reference that says that that transgender women are covered by CEDAW, not women in general, and that those things that needs to be taken account of in the provision of a new law. And that's, yeah, so there's some pretty difficult stuff in there. There's a whole chapter on discrimination, and I won't go into a whole lot of detail, but almost half of the references are highly questionable by the nature of the kind of claims that they make. And I'll just look at one of them, a couple of them. One of them is the survey of transgender people, which has been done by the Transgender Health Lab at Waikato University. And that research, which is described as, the best that there is in New Zealand, it results from a self-selecting survey. And it uses leading questions, and it kind of uses techniques that probably double the level of distress, suicidality, and so on that is present amongst the population. It asks leading questions. And in the write-up, it makes causal claims about the things that like, for example, suggesting that greater mental illness is caused by discrimination, when it's simply not possible to make those kind of causal claims about what's called a cross-sectional survey. It's just one of the things you don't do. And then another one right down at the bottom there, Morgane Auger, a transgender woman in Canada, is described as part of an extremely vulnerable and marginalized population. And a case that Morgane, I don't know how to pronounce the name, but was taken by him, resulted in a $55,000, $55,000 or $65,000 fine and costs. And yet it's well known that this person has been an enormously confrontational person in the Vancouver area towards the Vancouver Rape Crisis Centre. So we've got somebody described as massively vulnerable, who actually has been a huge problem to women in the area that he lives in. This is just a little example of something from Counting Ourselves. And it's about quality of life. Has your life got better or worse since you identified as transgender? And the question that's listed actually doesn't doesn't even ask the right question, and yet somehow magically it comes up with a result to show that most transgender people, 65% of their lives have got better. So it's a kind of pretty shonky piece of research. The next thing I want to talk about is there's nothing in the paper that talks about what's happened in Canada, in Australia, in the UK, where legislation that protects transgender and non-binary people has been enacted. And it just seems to me that if you're going to enact that legislation, you actually want to work out whether you're suddenly going to be criminalizing or punishing or taking to court people who are doing things which they have previously been able to do quite legally. And of course, that also impacts on being able to talk about, for example, gender medicine. It also impacts on, for example, being able to speak the truth about somebody's sex. It also has impacts potentially in people having the freedom to disbelieve in gender ideology. And I think it's quite important that we can disbelieve in gender ideology in the same way that we might disbelieve in any kind of religious practice. Yeah, that's one of the areas that's not been covered. And then another area is that there's a very, very close relationship in the legislation between our Health and Disability Commission legislation and the Human Rights Act, which the issues paper almost completely ignores. And it appears to me that one of the concerns that is really present is the idea that there is an apparent attempt to embed gender medicine as a legal right, even as the evidence for it is being found to be very poor. So there's no discussion in the issues paper of our conversion practices legislation, even though there have been multiple vexatious complaints, and there's been a really chilling effect on counsellors and doctors about doing other than gender affirmation. Yeah, that's really what I wanted to say. It's an incredibly difficult paper to respond to because of the way that the issues have been framed. And I'm going to hand over to Janet now. But one of the really powerful things that I think that some of the people who have responded has said have been to say that the level of social discohesion, if you like, between women and transgender people is so difficult, it's so problematic, there's so little discussion, there's so much silencing, that it's really going to be unwise to implement this kind of legislation until there has been a more public discussion and until there's been something which allows a broader range of people to kind of consider what actually might work, rather than putting a whole group of people in the frame of kind of what could be very damaging legislation in terms of freedom of speech, freedom of thought, the right to speak, the truth about who we meet and who we see. So that's me. Thank you very much, and I hope I haven't gone too far over time.
Thank you very much, Jan.
I think I
have. Women will have lots of questions, I'm sure. Thank you so much. And now I'd like to hand over to Janet. Janet?
Kia ora koutou katoa. I'm Janet, and I'm the New Zealand Country Contact for Women's Declaration International, as well as I'm a policy convener for the Women's Rights Party, and I've also had a little bit to do with the WDI UN committee as well. So I'm going to talk about why gender should not be put into the Human Rights Act, and I'm going to talk quite a lot about CEDAW and how these proposals would conflict with CEDAW. So yeah, I'm talking about this Law Commission issues paper, which has just been released, as Jan Rivers said, called A Review of the Protection in the Human Rights Act 1993 for people who are transgender, people who are non-binary, and people who have an innate variation of sex characteristics. So they've reached a preliminary conclusion which says an amendment to Section 21 is necessary and desirable to ensure adequate protection from discrimination to people who are transgender or non-binary or who have an innate variation of sex characteristics. And by that last category, they mean people with DSDs, differences of sexual development. Notably, although the Human Rights Commission thinks protection is already available under the sex ground, it also thinks reform is needed to clarify the law. And that's because, as Jan mentioned, the Crown Law issued an opinion in 2006 saying that people with gender identities were protected by the sex category, but that's never really been proven, and it's in fact highly questionable. And the Human Rights Commission knows it's questionable, and that's why they still want the law to make sure that gender people are covered. But okay, so moving on. So, you know, my basic stance is that gender harms women's rights. I think most of us nowadays who are gender critical have this view. It's a vague, imprecise concept, creates bad law. It's another name for sex-based stereotypes. Women's rights are sex-based, women's oppression is sex-based. When gender is introduced into law, it conflicts with and may eventually replace sex-based rights. Women can only fight for our rights if we can name who we are and what our oppression is. So the Convention on the Elimination of Discrimination Against Women, that's CEDAW, is definitely sex-based and provides sex-based rights for women. And as Jan Rivers said, you know, they hardly mention CEDAW, and she only spotted it where they are trying to incorrectly use it to say that it's protecting the rights of trans women. And I spotted it in one place where they're talking about how the current CEDAW committee is now asking New Zealand to do more for trans women, but that to me is just an indication that UN is starting to get captured now by gender activists, but definitely that is not what CEDAW was about, and everybody knew that for a long time in the United Nations. So Article 1 of CEDAW says, for the purposes of the present convention, the term discrimination against women shall mean any distinction, exclusion, or restriction made on the basis of sex, which affects women's human rights and fundamental freedoms. I'm not going to read all the words that are on my screens because I won't have time. So Article 5 of CEDAW says, states parties shall take all appropriate measures, and here when I've got stuff in blue, it's probably something to do with gender, to modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and other practices which are based on the inferiority or superiority of either of the sexes or stereotype roles. So CEDAW sees these cultural patterns as being stereotypes which should be opposed, in fact, eliminated, certainly not supported. So in 2010, the CEDAW committee definitely at that point still understood what CEDAW was about. And their recommendation 28 said that it started to look at, well, does CEDAW have anything to do with gender? And it said, the convention only refers to sex-based discrimination because it doesn't mention gender at all. However, interpreting Article 1 and Articles 2 and 5 indicates that the convention covers gender-based discrimination against women. The term sex here refers to biological differences between men and women. The term gender refers to socially constructed identities, attributes, and roles for women and men, and society's social and cultural meaning for these biological differences, resulting in hierarchical relationships and in the distribution of power and rights favoring men and disadvantaging women. So that's what the CEDAW committee was saying in 2010. And Reem Al-Salem comments on this recommendation 28 when she was asked to help provide a definition of women for the Tickle versus Giggle court case, which she didn't end up being able to be a special friend of the court, but she wrote gave some advice anyway. So she says, talking about the CEDAW committee recommendation, in the position paper on the definition of woman in international human rights treaties, and in particular CEDAW, she said it is clear that the CEDAW committee did not equate a person who may identify as a woman and a man with someone who is a woman or a man, the latter being defined either as biologically male or female. And Reem Al-Salem is the special rapporteur against violence against women and girls, if people haven't heard of her before. And she also said, while not addressing or defining the term sex or gender, many foundational human rights treaties and declarations, including CEDAW, enshrine a prohibition of discrimination based on sex, which can only be taken to mean as referring to biological sex. And this was reinforced by recommendation of the CEDAW committee, that the whole purpose of CEDAW is the elimination of all forms of discrimination against women on the basis of sex. Furthermore, Reem Al-Salem says that sex and gender are two different concepts where tension may arise between the right to non-discrimination based on sex and non-discrimination based on gender or gender identity. International human rights law does not endorse derogations from the obligation to ensure non-discrimination based on sex, or the subordination of this obligation not to discriminate based on sex to other rights. So CEDAW says you can't replace sex with gender or make gender more important, but this is what countries are trying to do around the world, and is what happens in practice. But it's actually breaking the CEDAW, their obligations to CEDAW. And here's a definition of gender from the United Nations. Gender refers to socially constructed differences and attributes and opportunities associated with being female or male, and to the social interactions and relations between women and men, and it's all about inequalities between the sexes. So the Women's Rights Party says something pretty similar. Gender is an imprecise concept that refers to sex-based stereotypes and social expectations. i.e. what is considered feminine and masculine. Gender identity and expression refer to the identification with and expression of those stereotypes. The United Nations didn't just, of course, have CEDAW. There are a number of United Nations conventions, and I would just like to refer to one of them, which is some United Nations rules for prisoners, which are being broken in New Zealand prisons, where they definitely specify that women prisoners should have their own separate institutions. That's in the Mandela rules, Nelson Mandela rules, and the Bangkok rules emphasizes the importance to highlight the distinctive needs of women prisoners and take positive measures to address structural causes of violence against women. Whereas in New Zealand, we've had violent men in women's prisons. And this is just on the interpretation of the current Human Rights Act, which is incorrect. So this was the old idea about what gender was and how important sex was. But gradually the idea of gender is being changed, and instead of being seen as a cultural construct, it starts to be seen as an inherent, internal and individual identity. And this is what the Yogyakarta principles were saying in 2010. It's each person's deeply felt internal and individual expression of gender, which may or may not correspond to the sex assigned at birth. And this was a group of men, I think mostly gay men, who got together on an island and wrote it, but it has absolutely no validity in international law. It's never been adopted officially by anyone. The Women's Declaration is highly critical of that definition by the Yogyakarta principles. And it says that gender identity maintains women's inequality. It says the concept of gender identity makes socially constructed stereotypes which organize and maintain women's inequality into essential and innate conditions, thereby undermining women's sex-based rights. The concept of gender identity has enabled men to claim a female gender identity to assert in law, policies, and practice that they are members of the category of women, which is a category based on sex. And they also talk about how it undermines lesbians because they no longer have the right to be same-sex attracted. And they also talk about how the erasure of sex is happening globally. There's a really good article called The Erasure of Sex, the Global Capture of Sex, the Global Capture of Policies on Sex by Gender Identity Activists and the Effects on the Rights of Women and Girls. You can find this on the Women's Declaration website. And it talks about steps to eliminate the legal category of sex, which starts with something fairly harmless, like apparently harmless, allowing change of legal sex under restricted conditions. And that actually happened in 1995 in New Zealand, in the Births, Deaths and Marriages Act that we had then. And you move down the steps until you come to step 4, biological sex is treated as private information and its disclosure is punished by law. Step 5, sex is replaced. The legal sex category is replaced with A, sex characteristics, B, gender identity, and C, gender expression. And we already see those 3 categories being quite promoted by the Law Commission. So Women's Declaration, of course, supports sex-based rights, and there's a whole list of all the articles are all about women's sex-based rights, which are based on CEDAW. And the Women's Rights Party has a very similar set of rights and principles. And also important to the Women's Rights Party is the freedom of speech right to talk about all these rights. So just things like having our own spaces, having fair play and safety in sports, and so on. And as soon as you get gender, these rights start to come under threat because someone claiming to be a woman who isn't can breach them. And so the Women's Rights Party proposed, has a list of biological definitions, and I think that some of these could be useful for the Human Rights Act. This would be the only change to the Human Rights Act that I would support, which would be to add a more clear definition of what sex means in the Human Rights Act. They do say sex, including pregnancy and childbirth. That's in the Human Rights Act. So I think it is indicating that the Human Rights Act intends sex to be understood biologically, but there's a little bit of room to squeeze there, which is why people like the Human Rights Commission are trying to pretend it's about gender. So I won't read all those definitions, but an example is human female denotes the sex with a reproductive system typically organized to bear offspring and produce eggs, distinguished biologically by the production of gametes, which can be fertilized by male gametes, and includes females whose reproductive system may be disordered in some way, and those females who choose not to reproduce. Like, we just felt we have to be very careful and scientific in how we define sex. And I'm actually quite astonished that laws now are trying to say that sex is not biological. I honestly never thought that would happen, but obviously it has happened in Australia, and it's at risk of happening here too. And the Women's Rights Party emphasises the importance of biological sex. In its policy, it says women's and girls' sex-based rights as biological females need to be protected in policy and law, and this should not be given precedence over any proposed provisions based on concept of genders. The sex-based rights for women in the Human Rights Act must be preserved. So let's look at the Human Rights Act. It does indeed talk about sex and include sexual orientation, but it does no mention of gender in it. So there's sex, which includes pregnancy and childbirth, and sexual orientation. And then Section 44 is about discrimination being prohibited when providing goods and services. And then we look at the exceptions. Section 45, this does not mean that you cannot discriminate on the basis of sex if you are, for example, giving a service for people of a particular sexual orientation, like counselling, where highly personal matters such as sexual matters or the prevention of violence are involved. And also, the next clause says, Section 44 would not apply to the maintenance or provision of separate facilities or services for each sex on the grounds of public decency and safety. So it's saying you can have women's separate sex spaces for these reasons. Now, the Crown Law was asked for an opinion in 2006 because there were proposals there to change the law and bring in gender. And the opinion of Crown Law, though, was that you didn't need to bring in more legislation because the gender people were already covered by the sex category. Now, that's just an opinion, and they weren't clear whether they meant people are protected as the sex they are or as the sex they want to be. And also, since then, we've had Section 79(2) of the Births, Deaths and Marriages Act in 2021, which makes it clear that gender identity does not equate to sex. So that puts things in a new light now in law. And here's a whole list of people who interpret the Human Rights Act already as protecting gender, starting with the Crown Law opinion. And you've got all these government bodies, councils, media, midwifery council, etc., police, who have listened to the Human Rights Council and already act as if there's already a law against offending anyone with a gender identity. But, you know, as I said, they're not really content with misrepresenting the law. The Human Rights Commission wants the law to be changed. Well, originally, as Jan Rivers was saying, there was a bill proposed, but it was dropped, I think, after the Crown Law opinion was made. So in 2023, that people started trying again. Elizabeth Kerikeri, a Green Party MP, introduced a bill trying to discriminate on the grounds of gender identity, expression, and variations of sex characteristics. And that has had its first reading in Parliament and is currently supported by the Maori Party, but doesn't seem to be moving along at the moment. Now, the Law Commission has put out an issues paper, which is a review of the protections of Human Rights Act for transgender people. So here's some legislation which already includes gender in New Zealand. We've got the Births, Deaths and Marriages and Relationships Registration Act 2021. It was amended in 2021 to bring in sex self-ID, and the Conversion Practices Prohibition Act. The Births, Deaths and Marriages Act really promotes a legal fiction. It pretends that if you're born, if your birth certificate says you're born a certain sex, then you were. But as I've already pointed out, it also acknowledges that therefore the birth certificate is not a reliable evidence of what someone's sex is anymore. The Conversion Practices forbids, it kind of puts pressure on people to affirm gender. It doesn't exactly say that, but there's a lot of pressure that way. The Midwives Council, meanwhile, has been merrily trying to ban the words mother, woman, and baby from their scope of practice. They didn't completely succeed, but this is the kind of thing that's going on here. We should reject it for all kinds of reasons why gender is bad for women, and it also harms free speech, which the Law Commission is trying to bring in by the back door now, some more hate speech prohibitions without calling them that. So there's ongoing confusion. Look at whether maybe we could introduce sex-based stereotypes that into the Act, saying we protect people for non-conformity to sex-based stereotypes. That has been proposed by the WDI in USA for their legislation, but I think it still leaves the risk that women might end up losing out, even with something as apparently harmless as that. So my recommendation is to leave the Human Rights Act as it is, with no changes to the grounds of discrimination in sections 21, except for the fact I do think that the definition of sex could be extended in the Human Rights Act to make it completely clear that sex means biological sex, and that they could use some of the definitions which the Women's Rights Party currently has. And this would end the confusion arising from the Crown Law opinion. So that's all from me. Thank you.
Thank you very much, Janet. So thank you to our NZ Aotearoa component and your discussion, which was very useful. Thank you so much. And now I would like to hand over to Anna Kerr. Please go ahead.
So I'm going to be talking about the case of Tickle and Giggle, which I'm sure everyone's already heard an awful lot of commentary on this case already. So I'll be talking very specifically about the decision, and if I use certain language that bothers you, it's probably because I'm quoting from the judgment. I'm just giving that warning. So this decision's just been handed down in the last, a week? Feels an eternity. So just to go over quickly, I'm sure most of you are familiar with these facts. This is the case involving Giggle and Sal Grover. So Sal Grover, having experienced sexual harassment and sexual assault during her 10 years as a screenwriter in Hollywood, decided with the support of her family that it would be therapeutic to set up a social media app exclusively for women and girls. And the app was specifically designed to enable women to meet safely online and network free of male harassment. It was, of course, under attack on a regular basis from males who attempted to register. But despite all that, it managed to accumulate about 20,000 users by 2021. Now, Roxanne Tickle, who's the applicant in this case, was a person who had various genital surgeries in October 2019. And then in accordance with Queensland law, Tickle's birth certificate was reissued with a female sex marker on the 18th of September 2020. These are facts taken from the judgment, by the way. In 2021, Tickle registered as a user with the Giggle app, having passed the gender detection system, only to be subsequently blocked and excluded some months later during a manual review of user profiles conducted probably by Ms. Grover herself as CEO of Giggle. And Tickle was at that point identified by Ms. Grover as being male. So Tickle then made complaints, sent emails and calls to Ms. Grover that weren't really responded to, and so then lodged a complaint with the Australian Human Rights Commission in December 2021. Tickle alleged discrimination on the ground of gender identity in the provision of goods and services. So this involves the joint operation of Section 5B and Section 22 of our Sex Discrimination Act, which is a federal piece of legislation. So as there was no prospect of conciliation, the Commission terminated the complaint, which then left Tickle with the option of taking the matter to the federal court, where the claim was ultimately heard by Justice Bromwich during a 3-day hearing in April. And then after 4 months of deliberation, Bromwich delivered his judgment on the 23rd of August. So Justice Bromwich found that it was, before I go to that, so look, this slide, which I hope you can all see both parts of it. So Sal Grover, it's like a summary, really. Sal Grover's attitude is law is supposed to reflect reality, and in reality, this person is a male. Whereas Bromwich says the acceptance of Ms. Tickle is correct. The acceptance that Ms. Tickle is correctly described as a woman is legally unimpeachable. So there we have the stark difference between the two perspectives. Just to be warned that both the language and reasoning adopted by Bromwich demonstrated an uncritical embrace of gender identity ideology as propagated by both Tickle's legal representatives but also the Sex Discrimination Commissioner. For example, Bromwich acknowledged at the outset that the term cisgender does not appear in the discrimination legislation and was opposed by the respondents, the Giggle team, and yet he proceeds to use this term no less than 30 times in his judgment without any sort of particular reflection really about that. Now, of course, Sal's view that the law should reflect reality sounds sensible, but those of us who are lawyers know that the law is full of legal fictions. So a legal fiction is a construct used in law where a thing is taken to be true when it's not in fact true, and this is done to achieve a certain outcome. I won't go into this. I've put a few on the screen, if you can see that slide, of some pretty well-known legal fictions. I would suggest that the courts need to consider really closely the implications of adopting these fictions. The law really rests on the telling of the truth, and I think we should, the legal system should lead by example. But it seems that at the moment, the law doesn't think reality should get in the way of a good legal fiction, to sort of paraphrase a quote from, I think, Mark Twain, who said the facts shouldn't get in the way of a good story. So lawyers have a similar view, it seems. So back to the details. So Judge Bromwich found that it was not established by the evidence that Sal Grover was aware of the applicant's transgender status. So when she took the decision to block Tickle, she did not know that Tickle was transgender. So accordingly, Bromwich found that there was no direct discrimination on the ground of gender identity because it just hadn't been proved. So that was a complete answer to the claim of direct discrimination. However, Bromwich then reasoned instead that Miss Grover had imposed a condition, the condition of needing to appear to be a cisgendered female in photos submitted to the Giggle app, and that this had the effect of disadvantaging transgender women who do not meet that condition, and in particular Miss Tickle. So that I'm quoting there from the judgment. So on this undisputed basis, Bromwich made a finding of indirect discrimination, despite observing that it hadn't been properly pleaded in the first place by Tickle's legal representatives. Throughout the judgment, Bromwich makes fair criticism of the pleadings and the conduct of the proceedings by both parties' legal representatives. So specifically, he complains that Tickle's pleadings do not coherently distinguish between direct and indirect discrimination. Bromwich also notes that the respondents failed to identify this shortcoming or to object to the amendment of the pleadings in this regard. So despite this failure to plead Section 5B2 clearly, the judge kind of works to correct this deficiency so that he can ultimately support his finding of indirect discrimination. So the court's less helpful when it comes to repairing the shortcomings of the respondent's case or the Giggle case. A claim of indirect discrimination enlivens another section, Section 7B, which provides a defence when the condition imposed, the condition, requirement or practice, that is reasonable in the circumstances. So unfortunately, the onus to establish that rests on the respondent. So they have the burden of satisfying the reasonableness test. Unfortunately, no doubt because they perceived the case as one of direct discrimination, the respondents failed to plead Section 7B and did not rely upon this defence in their submissions. Bromwich didn't repair this shortcoming. despite the fact that really the respondents could have won the case really by default had he taken an equally rigid approach to the failures of Tickle's legal team. The evidence in the proceedings provided an ample basis for the argument that the condition of excluding males did not result in any real disadvantage to Tickle, who had in fact conceded in evidence that he made very little use of the app and he found it boring. Furthermore, multiple affidavits tendered into evidence by the respondents, which appear to have been dismissed in a rather cavalier fashion by Bromwich, but they all provided extensive support for a finding that the condition imposed was proportionate and reasonable to ensure reliably safe single-sex spaces for women free of male harassment. But he didn't give that his attention. So instead of pleading Section 7B, the respondents had relied very heavily on another section, Section 7D of the Sex Discrimination Act, which provides an exception from discrimination provisions for special measures intended to achieve substantive equality. This section enacts Article 4 of CEDAW and makes provision for affirmative action provisions. In other words, you can have discriminatory provisions where they're intended to help a disadvantaged group achieve substantive equality. So things like quotas and affirmative action measures. However, although Bromwich accepts that the Giggle Act may constitute a special measure when it comes to the exclusion of cisgender men, he does not accept it as a shield to guard against claims of discrimination on other grounds such as gender identity. Since Bromwich accepts that trans women fall into a category of women, he cannot countenance the respondent's argument that Tickle was excluded because and only because he was a male. Interestingly, Bromwich does not seem to consider whether there could be a claim made for a special measure on behalf of cisgender women to exclude those who identify as trans women. This is perhaps because cisgender women are regarded as the more advantaged group, despite the fact that their spaces and services are entirely excluded from funding and acceptance if they do not agree to embrace gender identity ideology. Ultimately, the difficulty is that Bromwich uncritically accepted and adopted the submissions of the Sex Discrimination Commissioner, who those submissions were, firstly, sex is not confined to a biological concept. Secondly, sex can refer to a non-binary status and can be changed. Thirdly, the determination of sex can take account of legal and social recognition. And fourthly, the sex discrimination provisions must now be read in the context of the amendments to the Sex Discrimination Act in 2013 that added gender identity protection. So Bromwich accepted all of that, saying that it was grounded in logic and long-standing authority. In contrast, Bromwich finds the expert reports relied upon by the respondents, the Giggle team, as to the immutable nature of sex from both scientific and philosophical perspectives, with reports from both evolutionary biologist Colin Wright and academic Kathleen Stock, to be of no use to the respondent's case. Bromwich also rejected journalist and author Helen Joyce as an expert. He rejected her as an expert altogether, despite her having authored a book on trans when ideology meets reality. But he found that she had no formal qualifications of relevance. He stated instead that she is entitled to her opinion, but it is of no assistance to the respondent's case or to this court. So I suppose we should be grateful for this small concession that she was entitled to her opinion, because we're increasingly in an environment where we feel as if we're not entitled to an alternative opinion on this subject. Increasingly, we're being told that dissent on this topic can constitute hate speech. The respondents, when I say the respondents, I'll just say the Giggle team. The Giggle team also tendered 14 affidavits of lay opinion, ordinary people's opinions as opposed to experts, often on the crucial importance of female spaces and these were similarly dismissed by Bromwich as having no bearing on the matter. There was no cross-examination of any of the respondents' experts or lay witnesses. Instead, the court relied on case law going back over 30 years, which Bromwich states has broadened the concept of sex, leading him to claim the acceptance that Ms. Tickle is correctly described as a woman is legally unimpeachable. Strangely, Bromwich didn't enter into any detailed analysis of the case law in question, despite it really being at the crux of the case. He just simply accepted the submissions of the Sex Discrimination Commissioner, and we're really left curious whether he had an independent view of the authorities cited. Of course, there is another section of the Sex Discrimination Act which was was not pleaded and received no attention in the judgment, and that is Section 32, which states that discrimination provisions do not apply to the provision of services, the nature of which is such they can only be provided to members of one sex. I would think that that could provide specific protection of the kind needed by the respondents, but this provision was, of course, going to be rendered inoperable by a finding that Tickle was a female. So basically the respondents had argued that Tickle was excluded on the basis of sex rather than gender. That argument was rejected because Tickle was accepted as being a woman and that his claim was on the basis of gender identity. Tickle was not claiming to have been treated less favourably than a man. Tickle was complaining about being treated as if he were a man. So a key defence of the respondents was to challenge the constitutional authority for the 2013 amendments to the Sex Discrimination Act, which introduced the protection of gender identity. The Giggle team argued that CEDAW does not extend its protections to gender identity only to sex, and therefore the amendments are not supported by the External Affairs head of power under the Australian Constitution. But Bromwich found that CEDAW just wasn't relevant at all because the Convention does not extend to protecting one category of woman from another category of woman, and because he'd found that Tickle was a woman, therefore it had nothing to do with CEDAW. Instead, Bromwich referred to the fact that the gender identity provisions are supported by the more broadly worded Article 26 of the International Covenant on Civil and Political Rights. This article protects against discrimination on various grounds, including other status, which Bromwich was convinced does include gender identity. So he dismissed the respondents' arguments that Article 26 is too general and vague to be relied upon and accepted that. In any case, Bromwich also found that Giggle is a trading corporation. And in fact, as a trading corporation, the Commonwealth can make laws in relation to it under another head of power under the Constitution, really rendering all these arguments in relation to the external affairs power somewhat redundant. There was a second constitutional argument that was put. This one, it related to there being an inconsistency between the Federal Sex Discrimination Act and state laws which allow for change of sex on birth certificates. The idea is if there's a state law that's inconsistent with the Commonwealth law, then it's going to be invalid to the extent of that inconsistency. So the Giggle team argued that, in fact, being able to change sex created an inconsistency with the protections of sex under the Sex Discrimination Act. However, of course, the 2013 amendments somewhat undermine this argument since they removed the definitions of man and woman. But Bromwich said that even if those definitions had remained, there would be no inconsistency because the Sex Discrimination Act is not exhaustive and it does not impose its definitions on the states. So even if we had those definitions put back in, which I think Claire Chandler was attempting to do at one stage, it wouldn't be a problem. So the bigger problem that we have is that the states have now almost basically all of them have now allowed for change of sex on birth certificates. So Bromwich really dispensed with all these arguments really quite quickly, with really very little angst, considering the complex constitutional and philosophical considerations about the nature of sex and its protection. But he then spent 10 pages of his judgment on a detailed legal analysis in relation to the assessment of damages. And that's quite peculiar, considering that Tickle didn't put on any expert evidence to quantify the loss claimed. He didn't put on anything from a doctor as to the exacerbation of his pre-existing psychiatric condition, and generally failed to provide specifics or justify seeking the amounts of $100,000 in general damages and $100,000 in aggravated damages. However, the Giggle team can be grateful that by rigid application of a certain section, I won't bore you with, Bromwich found that it was inappropriate to make any award of aggravated damages. Basically, we're saying that the complaints that related to actions that took place after the lodgement of the complaint shouldn't attract damages because they weren't part of the original claim. So instead, the court ordered a payment of only general damages in the sum of $10,000. So this is considerably less than Tickle's ambit claim, but it's still arguably a grossly excessive sum for findings of modestly hurt feelings and the loss of access to a social media app, which he admitted to having made minimal use. So Bromwich recognises this was a case brought on principle rather than due to any lasting hurt or disadvantage. So really should have acceded to the respondent's submission that an award of damages should be nominal. Due to the complete lack of evidence and precedent upon which to base an assessment of the quantum of damages, Bromwich relied instead upon an instinctive synthesis to make his award, and after considerable thought and reflection, reached into a hat and pulled out $10,000. It's to be wondered whether that thought and reflection included considering that $10,000 is the maximum recognition payment available to women in New South Wales who are primary victims of sexual assault resulting in serious bodily injury or multiple offenders or an offensive weapon, etc. So I don't know, but perhaps it was Ms. Grover's conduct in court laughing at an offensive caricature of the applicant that convinced the court that this offensive and belittling behaviour should result in an award commensurate with the amounts paid to victims of violent sexual crime. I don't know. However, that would be arguably inconsistent with the statement made by Bromwich at the outset that the court has power only to compensate, not to punish the respondents. In any case, the award of costs against the respondents is definitely going to be far more punishing than the compensation to be paid to Tickle. And these awards are awarded by the court despite not having been originally sought in the applicant's pleadings, and they're only partially capped. The cap of $50,000 only extends to the work that is involved in the constitutional and statutory construction arguments, not to all aspects of the case. Originally, there had been the applicant had floated a general cap on costs of $20,000, but unfortunately that was rebuffed at an earlier stage by the respondents' team. Sensibly, Bromwich declines to order a forced and insincere apology or to order Tickle's reinstatement to the now defunct social media app. The wording of the declarations to be made in Tickle's favour are yet to be finalised after consideration of proposed wording by the parties. And that's the end of my slides. So look, just to conclude, Bromwich now has the very dubious honour of being the first judge to decide that it is possible to change sex in a context where the result of his decision is to directly destroy any prospect of women and girls continuing to enjoy safe single-sex spaces and services. While laughable in its reasoning, the implications of this decision are no laughing matter. I think I'll stop there. Thank you.
Thanks, Anna. That was terrific and depressing. So thank you very much. I would like to thank our speakers, Jan Rivers, Janet, and Anna Kerr. Thank you. And we will end the recording and we'll go to question time. Thank you very much. I know that there is very loud applause currently coming through.